In this insider-exclusive network TV special, America's Medical Malpractice Crisis, What You Need to Know, we visit with Andy Siegel at the Siegel and Coonerty law firm. As we take you inside today's legal system, examining lawyers' strategies and clients' thoughts, and in vivid detail showing you the often heartbreaking stories of these clients, dramatically demonstrating what motivates Andy to fight for his clients' causes. Andy Siegel, our featured lawyer, has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in New York. He has seen many innocent and hardworking people injured and killed by negligent and incompetent doctors, hospitals, and nurses. Andy's passion is problem solving. He approaches each case as a scientist trying to solve a puzzle. He has seen many patients suffer needless injury, and because of that, he is driven to help people who have been harmed by incompetent and negligent doctors. Andy's goals to get justice and fairness for injured people, safeguard victims' rights, and to help guide the hands of justice. This is the Insider Exclusive, live from New York. It is my great pleasure to introduce Andy Siegel to the show. Welcome to the show, Andy.
Thank you for having me back, Steve.
Tell our audience a little bit about what your law firm practices and your expertise.
Our law firm has a focus on personal injury, traumatic brain injury, and we do a select amount of medical malpractice.
When I've listened to you talk about, in many of your cases, medical malpractice cases, it almost sounds like you know as much as the doctors or more.
If you don't know more or as much as the doctor, in court, you will fail in your navigation of the courtroom.
There are, for our audience, why don't you give us the definition of medical malpractice? Because there's a lot of people who really don't understand what is medical malpractice.
It's defined, at least in the state of New York, as a departure from good and accepted medical care. What that means is that the offending doctor did something under the circumstances that they should not have done, or failed to do something under the circumstances that they should have done. Their conduct departed from the accepted standards of care by not doing something, or by doing something that they shouldn't have done.
Now, there are many medical malpractice cases that are filed. Some are dismissed, some are lost, some are won or settled. When you use these terms, which seem rather ambiguous, about departing from the reasonable standard of care, as a lawyer, don't you have to present in any kind of case examples of other cases where that was shown to be true because it was almost the very same action that this doctor failed to do or did?
Yeah, I mean, that's an interesting question. The answer is no two medical malpractice cases are ever the same. There's always a different fact pattern, and in one fact pattern, the doctor who did something could have departed from accepted standard of care. In a very similar fact pattern with maybe just one little change of fact, that same conduct may be in conformity with good and accepted medical practice.
I have, for the record, I believe that most doctors are very good doctors.
And I share that.
And nobody is perfect. Mistakes are made.
I share that too.
I've seen and I've read that when some doctors make a mistake, they want to readily admit it to the patients or the patient's family. But I've seen that insurance companies and hospital staff don't want that to happen, right?
Very broad question, Steve. So in my 30-year career, I've only been involved in one case where the doctor embraced that they did something wrong. They didn't even tell the family. It was through the hospital facility and my involvement with them that they said, yeah, the doctor has acknowledged what has happened here. But otherwise, I don't see that. I don't see doctors telling their patients, hey, we made a mistake. I've heard this was a risk and complication of the procedure, which is their term for we did nothing wrong.
And there is a consent form when you talk about risk, which kind of covers their rear ends sometimes, because there's risk in all kinds of surgery.
Absolutely.
You being a lawyer and having to know exactly, did they follow the right procedure and that sort of thing, this becomes very technical, doesn't it?
It can. A lot of these cases are very technical. The most technical case I ever had was a case called Park. In the Park case, this woman came to this country, began working at a nail salon. The ceiling collapsed on her head. She went for a CAT scan, had never had any treatment medically in her country for anything ever. It was literally the first time she ever went to a doctor. CAT scan was read as negative, but 30 days later, an aneurysm ruptured in her brain. What I did was I got the CAT scan film from 30 days earlier and I had it analyzed. But the challenge in that case was I had to prove that there was something imaged on the CAT scan that was abnormal. CAT scans do not pick up aneurysms. So I had to show there was an abnormality on the CAT scan, that if the doctor had picked up the abnormality, he would have referred her for an MRA, which is a study that outlines the vessels within the brain. I would have had to prove that if an MRA was done, that would have been positive. That if the MRA was positive, she would have had a brain surgery to deal with the aneurysm before it burst. And I had to prove that that surgery statistically would have been successful, and that she would have been okay and not sustained any of the injuries that she did from her aneurysmal rupture. In this case, I had to jump through all those hoops to prove a simple case of the doctor didn't see what was there to be seen in a picture.
And that resulted in a rather large verdict, right?
Yes, that was a $43 million jury verdict. Interesting enough, I had only asked the jury for $4 or $5 million, but I think that the manner in which the case was handled at trial and the way the particular doctor presented himself created a very tense atmosphere in the courtroom. And, I think the jury, in essence, punished the doctor for testifying. I didn't see it. Maybe I saw it. It's there. It's not there. The wishy-washy manner of the doctor's testimony, where he tried to say 5 different things, except, the one thing he was paid to say in the day that he rendered care to the patient, which was, there's an abnormality here.
What is, when people select a lawyer for these complicated cases, what is it that you always tell everybody that you want to tell them on camera right now? Not necessarily about the verdicts they've won or the settlements they've gotten. What advice do you have to folks?
Step 1 is interview more than one attorney, okay? Different attorneys may have similar abilities, but they may or may not connect with the individual. That's step 1. So you interview more than one attorney. Number 2 is, I believe you should ask that attorney what the largest amount of money ever was that was offered to one of their clients that they advised the client not to take, and then what the ultimate resolution was by jury verdict. I think that's the barometer that measures an attorney's effectiveness and ability in a courtroom.
I'm looking right now at a number of cases you provided us where the insurance company offered 0 for probably 10 cases. Maybe you've talked about one of them, Park. There's other cases that come to your mind. What would be some of them and some of the the details behind it?
There have been several medical malpractice cases that I've handled that there was no offer of settlement, yet the jury has rendered a large sum of money.
Weiss versus Fiesel.
So Weiss, she had a perforated bladder as a result of hysterectomy. I was actually thinking about that case. There was no offer of settlement, and the jury came back with a substantial verdict.
That was $2 million.
$2 million.
Simmons versus Tolia?
Yeah, Simmons. So in Simmons' case, it was an absolute crazy case. There was no offer of settlement. An adult, a man, had a circumcision. Afterwards, he was unable to get erections the way he did beforehand. The defense was that he had a condition known as Peyronie's, and our claim is that the circumcision was done wrong. It caused the tethering of his private parts during an erection, making a move to the left. And the jury gave over $1 million on that case.
Right. There was another one, Bruno.
Yeah, Bruno. Yes, Bruno. So in Bruno, a doctor, Mr. Bruno, went in with a subdural hematoma. It was to be evacuated. The neurosurgeon, unfortunately embedded a Jackson Pratt catheter 2.5 inches deep into the motor cortex that was just supposed to be at the operative site to collect postoperative serosanguinous fluids.
Let's say I'm a patient, I have a loved one that I think has been, is a victim of medical malpractice. What should I do? I'm a family member. What should you do? And what are some of the difficulties and challenges that an individual person, not a lawyer, has starting off?
Malpractice, I've always seen as like a slap in the face. You're very aware of it. So if a family believes that proper care wasn't rendered, it's usually a very high level of emotion, like how did this happen? And those are the kinds of cases that I get involved in, like in the Bruno case that we just spoke of a second ago. The son was smart enough to know that something happened to his dad. He signed out the images from the hospital facility, had them read at another hospital, realized that his father had this drain embedded in his head, and started finding attorneys. In that particular case, again, that was a no-pay case. They offered no money, and it ended up, the jury gave this, he was in his 80s, the man, for 4 years of pain and suffering, $6 million. And it was the 9th largest verdict in the history of Richmond County in Staten Island.
I remember that case, the son ordered copy of the medical records, and he had some familiarization with reading some of these records, and he discovered that they had been read wrong.
Yeah, it was even deeper than that. This was a catastrophic situation of immorality. The patient, his father, and the son was told that postoperatively the father had a transient condition known as Todd's paresis, which can happen after certain brain surgery that goes away in 10 days to 2 weeks. It wasn't going away, and there was a facial droop and hemiparesis, or inability to use one half of the body. And so what the son did was he actually signed out the images and brought them to another hospital and had them correctly read. There was really nothing in the record. Actually, in summation, I told the jurors that none of the defense was actually in the hospital record. There was absolutely no mention of the catheter having been embedded in his father's brain, other than them saying, oh, this condition was Todd's paresis. It was a crazy case.
So a relative of a patient, or even yourself, if you're a victim of this, you can request your own medical record.
Sure, with a proper authorization under the HIPAA laws.
And today they're automatically given to you. Is that right?
We generally don't have issues getting medical records. There are laws in effect that require that they be furnished. I will say that I've been around since records were handwritten, where I could see an alteration. Now we have more of the digital records, and you can see when people go back into the records. But what I find the problem to be now is I'll request the records in their entirety, and I'll get portions of them that are being held out as the entire record.
You have the records. Should you make a report to someone, like make a report to the hospital, or does it do any good?
Listen, again, like we started this show, we both have a healthy respect for the medical profession, but they're really, really bad at policing themselves. So I would suggest that even if you reported it to the institution, not much would get done.
When you mentioned earlier about selecting a lawyer for a medical malpractice case, it's very important, right, to talk to somebody who's had experience, who knows the tricks. I would say the dirty tricks sometimes. Not that the doctor usually does, but the insurance companies who's representing them to try and defeat your lawsuit, right?
Yeah, I mean, listen, the insurance industry pretended there was a malpractice revolution way back when. The Harvard study did away with that. You know, they reduced the fees in such cases. You know, the denial has been around forever. So it takes lawyers to represent survivors of medical malpractice to bring the truth forward so it's recognized. But even then, Steve, I got to tell you, when the case is resolved, a lot of times they won't want to pay you the money unless you sign a confidentiality agreement. And so that way the public doesn't even know of this horrific situation.
And what do you recommend to patients?
It depends. Look, when I resolve a case that went to trial and a jury spoke on the case, I never sign a confidentiality agreement because it's a matter of public record. There are times where I have to get my client compensated due to their life situations and offers of money are being made. And although I don't want the clients to sign a confidentiality agreement, it's in their best interest in their particular lives to do so.
There is a statistic out there that I found to be pretty accurate, and that is roughly 3% of the doctors cause 30% of the medical malpractice lawsuits. It would seem to anybody doing the numbers would say, well, why don't we get rid of the serial offenders, right? That doesn't happen. Why not?
Because, again, the profession doesn't do a good job policing itself. And then we have the people who license the doctor. They'll only begin to act if a complaint is made against the doctor. And then the parties who make the complaint against the doctor, each subsequent person would have to know to make the complaint to the Department of Education, the Bureau of Licensing for that doctor, for there to be accumulation of material that a governing body would have to make such a decision to remove a license from a practicing physician. Certainly, the insurance industry is not going to be making those recommendations because this is the doctor who's paying their premiums.
So it's a real big conflict of interest there, isn't it?
It could be a better system.
Anything else to advise everybody watching this about why your law firm is probably, in my estimation, one of the best firms to go to for medical malpractice, simply because of your technical knowledge and success rate?
I would say that because of the selectivity that we have in this firm, I'll get a month, maybe 30 calls of a malpractice case, and maybe I'll take one of them. Maybe I'll take 10 a year. And because we're selective on the cases that we take, we have a very high success rate because remember, Steve, we work on a contingency fee. So we want to be involved in the cases that we believe have merit. So why should someone select my firm out of some other firm? Because they connect with me and Sean and my staff. They understand that we have wisdom and a proven track record. And I personally promise that I will give it my all if I get involved in a case to seek justice and achieve it for them.
Thank you very much for being on the show, and we wish you continued success.
Thank you, Steve, for having me again, and I wish you well.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.